Welcome back to In Focus. We have another update on the FBI raid of President Trump's Mar-a-Lago home. This after the Justice Department admitted in a court filing on Monday that it had reportedly seized material that was, quote, potentially containing attorney-client privileged information from Trump's Florida residence. According to the reports, the DOJ acknowledged the find in a submission to the U.S. District Judge Elon Cannon, who's weighing a request from Trump's legal team to appoint a special master to oversee the FBI's review of the documents seized during the raid. Now, of course, the left is freaking out about this as if it finally the golden ticket to lock him up. Never mind the fact that the investigation is nowhere near finished and that the DOJ won't tell us hardly anything. Blue checks on Twitter are also chiming in, like NBC's Tom Winter, who said the Justice Department asserts in a filing that some of the documents seized from Mar-a-Lago were so sensitive and classified that in some instances the FBI agents and DOJ attorneys needed additional security clearances to review them. He then followed up that tweet with a photo of the supposed super sensitive classified documents. Yes, these top secret documents that are scattered all over the floor, photographed and shared with the press, and now all over Twitter, all over the world. Too secret for them. They had to get special clearance before they shared it to everyone on Twitter. Not suspicious. We definitely shouldn't question that. It's got to be legit. Criminal defense attorney Bob Bianchi joins me now with a legal perspective on all of this. Bob, I want to focus in on the DOJ saying that the FBI seized possible attorney-client privileged information in the Trump raid. That could obviously be a big problem. What would be the repercussions of that, and what leverage could that give Trump legally in his lawsuit that's ongoing?
None, really. This was addressed in the affidavit. There's multiple times that attorney-client documents are seized, sometimes through a warrant. They have a team that goes through that. Supposedly, they've identified some of those documents, and those documents don't get delivered to the Department of Justice to be used in the investigation/prosecution of an individual. So there's nothing unusual here. The only thing that would be problematic is if they knew that they had an attorney-client privilege document that was outside the parameters of the warrant, then that would be a different situation. But it seems, and again, I try to just do the legal analysis here, right, that they follow the protocol that they always follow when executing search warrants. So I don't think there's anything to really see here.
And what do you make of this image that's circulating all over Twitter? You know, they said they had some of these documents were supposedly so top secret that they had to get special clearances, additional special clearances to even review them. But then, you know, they take a picture of it and they share it with the press, and now it's all over. That would seem to me to be a little unusual to claim that it's so hypersensitive that even the FBI top government officials have to get permission to open it, and then they just share pictures to the press. Does that strike you as unusual?
Well, I don't know how the press got those photos, but I think it would be inappropriate for them to share it with the press. Most likely, these things get out because of the unforced error that's occurring with regard to going to court and filing and looking for a special master, which I don't even think is needed at this point in time because the FBI has gone through all of the information already. That said, this seems to me to be something that was submitted via a court document, and maybe the press got it from there. However, if the DOJ or FBI leaked it to the press, yeah, it's somewhat problematic. Now, we don't know from that picture that these are the highest level security documents, and those documents don't say or show anything, at least when I was pinching in and out trying to take a look at them. So I think it all depends on where the information came from. But this is what happens, Addison, when you file court proceedings, the other side has an opportunity to respond. And it hasn't been, in my estimation, if I were the legal counsel, I'd be saying that, one, a special master isn't needed. It may sound nice. It may play well in the court of public opinion. But when you file a court document, you've got to back it up, and they have a right to respond. And this is their response. And the more information that comes out, some would argue, the uglier it's getting.
Yeah, and well, you know, there's going to be stuff ongoing. This is going to be making headline news for several weeks, and until we get some more answers on that, because you know a lot of I think 11 pages of the affidavit were redacted, and then they released the reason for redacting the affidavit, and those reasons were redacted. So still a lot of unanswered questions. One thing that I do want to get your opinion on as well is this from Fox Business: Elon Musk files another notice to cancel the Twitter takeover. This time time citing the whistleblower's data privacy concerns. A Twitter whistleblower came out and alleged a lot of the corruption and the privacy concerns, security concerns happening within the company. Musk is taking this and trying to use it as a way to get out of the $1 billion cancellation fee. What do you make of this from a legal perspective?
Well, I know that they have a trial in October, and the judge in the Chancery Court, I believe it's in Delaware, wants to move this case as quickly as possible because of the harm to the shareholders and Twitter itself. What Musk's people are now saying is that this information is relevant to their case, that they should have known it. They're adding that as another part of their complaint, that they should be allowed to be relieved from their contractual obligations, and asking the court to extend the trial for another month. So I think it's relevant. Of course, Twitter is going to say that this is a disgruntled third party and it should not be admitted. But I don't see in my mind how it is that a court, if they're allowed to amend their complaint, which are usually liberally granted, that this information would not in some way, shape, or form come out by Elon Musk to say this is yet another reason that if I had known this, I would not have entered into the contract.
And Bob, we've had you on several times to discuss the Twitter takeover, if you will. And so looking back from a 30,000-foot view, all of the hundreds of articles, the hundreds of updates that have come out about this ongoing dispute, what do you see playing out? Do you think it's more likely that Musk gets out hands-free, or do you think that he's going to end up having to pay up?
That's a tough one, Addison. But if on greater balance, if somebody came and said you have to make a decision right now, I think it's going to be very difficult to break the contract. You have due diligence, you have lawyers on both sides. Unless there's literal fraud that's occurring, I think that he's going to wind up at least paying the penalty. In my mind, if I had to guess one way or the other, because these are not unsophisticated people. Quite to the contrary, they're very sophisticated, and they should have done their due diligence. And if they didn't do their due diligence, that's on them.
We will stay on top of these updates. Bob Bianchi, always great to have you on the show for your legal perspective. Really appreciate it.
Oh, of course.
Coming up next.